Welcome back to Freedom, Facts, and Firearms. My name is Novak, and today we'll be looking at a portion of the English Bill of Rights. If you remember from the last episode, the monarchs of England started implementing strict gun control measures and bans. This did not go over well with the people, and multiple wars occurred. After the abuses of power by Charles I, Charles II, and James II, the Stuart family's reign came to an end. Parliament crowned William and Mary the new monarchs, but under certain conditions, which led to the English Bill of Rights being created in 1689. The right to arms was one of the rights incorporated into it. Parliament declared the ancient rights, and thereupon the said lords spiritual and temporal and commons do in the first place, as their ancestors in like case have usually done, for the vindicating and asserting their ancient rights and liberties declare, that the raising and keeping a standing army within the kingdom in time of peace, unless it be with the consent of Parliament, is against the law. The subjects which are Protestants may have arms for their defence suitable to their conditions and as allowed by law. One of the main takeaways from these events was that there had never been a written right to arms for the English people prior to this. So the declaration by Parliament that it was an ancient right means that it was so common and ingrained into society and culture for centuries that it carried the weight of law, something that we today would call common law. It dated back to the Anglo-Saxon rule in the 800s and continued through 1671. The right was not absolute, though, as certain weapons had been banned throughout time, and the stipulation of "suitable to their conditions and allowed by law" gave final say to the government and not the people. This is an aspect the American founders took notice of and criticized, which we'll get into later. Catholics were excluded from the right to arms due to feuds between the French and Spanish Catholic monarchs and Pope with the English Anglican monarchs. However, in 1689, Catholics were allowed to have arms under the condition they swear loyalty to William and Mary, or should a justice of the peace issue them a permit to defend their home or self. After the English Bill of Rights was passed, some gun restrictions would begin to be removed. A 1692 Game Act was passed that omitted firearms from the list of banned devices. In 1694, the 1548 statute that banned hail shot and required people of certain income levels to register handguns and crossbows was repealed. These rights and actions were a start, but not good enough for the Americans, who through their charter agreements were granted all rights the English had as well, and in some instances even more they didn't. In 1789, at the First Congress, James Madison introduced the Bill of Rights. According to Madison's notes, he viewed the English Bill of Rights as a good start, but too weak. He wrote that his amendments relate first to private rights. He also noted that the English Bill of Rights was a fallacy, as it was an act of Parliament and could be overridden by a future Parliament. This is a key statement for legal arguments today. It shows that the founders rejected that the government even be allowed to determine what arms could and couldn't be used or what objects fell under the category of arms. To claim arms ownership is a right, but allow the government to make laws and restrictions on that right meant it was not a right at all, and it was not protected. It could be changed on a whim at the government's pleasure. The American government has no authority to decide which arms are or aren't protected and which arms can and cannot be used. All arms are protected and the government has no say in the matter. Madison also noted that the scope of the English Bill of Rights was too small. It omitted certain rights and protected others too narrowly. Specifically, there was no freedom of press, no prohibition of GI warrants, no protection for habeas corpus, no guarantee of a jury in civil cases, no ban on criminal attainders, and lastly, that it only protected arms to protest. This once again shows that no limits were to be placed on arms ownership in America. It was rejected that a single aspect of life or action could dictate what arms you could have. when, and for what purpose. At the time, Americans believed the game laws and arms laws in Britain were strictly enforced and that almost the entirety of the population had been disarmed, whereas the reality was that the laws were near total failures and arms ownership was widespread. Since the Americans did not know this, they based their understanding off the English statutes and denounced the English laws. The basis for differentiating the difference in English and American laws and taking a pro-gun stance during the time came from St. George Tucker's American Blackstone, which is one of three major legal and historical writings used in U.S. firearms cases today, the other two being the case of Sir John Knight and the Statute of Northampton, the last of which should not have any bearing, weight, or standing in U.S. courts as it was fully rejected by the founders and created prior to the discovery of North America, but it's a go-to for gun control advocates. So as you can see, the intentions and actions the founders took on arms were quite clear, and it will become clearer as we go through more history and law. There are to be no restrictions on arms for law-abiding citizens. Thanks for watching Freedom Facts and Firearms, and we'll see you next time as we take a look at what arms and arms technology were around at the time the Second Amendment was written.